Senator Luetkemeyer.
Here.
Senator Schroer.
Here.
Senator Coleman. Senator May. Senator Roberts.
Here.
Senator Thompson Rehder. Senator Trent.
All right, we have a quorum. First up, we're going to go ahead and start with Senate Bill 1098. Senator Roberts, whenever you are ready.
Good afternoon, Senators. I'd like to thank the Chair and members of this committee for affording me the opportunity to present Senate Bill 1098 relating to inmate phone call fees. This is a bipartisan bill with a similar bill sponsored in the House of Representatives by Representative Davis and McMullen. Senators, SB 1098 is a bill principled in the understanding that all human beings are anchored in life through our relationships with our families, our friends, and our loved ones. When any of us faces our greatest challenges, those connections are at their most critical. What could be a greater challenge to an individual than the isolation of serving time in jail or prison? If we seek to rehabilitate and to see individuals grow through our correctional facilities, we must ensure that they are able to anchor themselves in those relationships just as we do. What Senate Bill 1098 does is ensure that inmates are afforded the opportunity to communicate with the outside world by establishing caps on phone rates that they may be charged in Missouri's correctional centers and jails. These caps are not set at a rate below the cost of the department, as it is not the intention to put a strain on our state and local departments, but they are set to rates to ensure that our state and local departments are not taking advantage of a captive population at one of their greatest points of needs. And with that, I'd gladly answer any questions.
Great. Any questions for Senator Roberts? Seeing none. Witnesses in support. Witnesses in support of Senate Bill 1098.
Mr. Chairman, members of the committee, my name is Jeff Smith. I'm representing Missouri Appleseed, a nonprofit based out of St. Louis that works on behalf of low-income families, particularly those impacted by the criminal justice system. So broadly speaking, first I want to thank the sponsor for bringing this bill forward. There are multiple bills in the House as well, which he may have referenced. Broadly speaking, again, there are only two things that research has shown that can happen during a person's period of incarceration, which have been shown to reduce the likelihood of recidivism. The first one is gaining an educational credential while incarcerated, and the second one is staying in close touch with an incarcerated person's loved ones during their period of incarceration. So we appreciate this bill because it will make it more likely that people can stay in touch with loved ones and therefore less likely to recidivate. Currently, 19% of Missouri jails charge $5.25 for individuals to place a 15-minute call to their family. And that means that if an individual speaks to their family for 15 minutes a day, it would cost $147 per month, $958 for 6 months, nearly $2,000 for a year in jail just for 15 minutes a day speaking to their loved ones. In a survey, 62% of fathers in jail spoke on the phone with their minor children at least weekly. 22% spoke on their phone with their minor children daily. We know that one of the causes, something that tends to be a cause of dropping out of school and other involvement with the criminal justice system for young people, is lacking both parents in their lives. And so we think this bill can address that proactively on the front end. We also know that people in jail and their families are often poor. According to recent data, men held pretrial had an annual average income of $15,598, while women held pretrial had an average annual income of just $11,071. That makes it prohibitively difficult to stay in touch with loved ones if costs are exorbitant, as I mentioned a minute ago. So we're very grateful to the sponsor for bringing this forward. We think it can protect the mental health of people in jail as well as their loved ones. It has also been shown to reduce the likelihood of substance use post-release, to stay in touch with loved ones. And so there's a lot of reasons to support this bill. The final one I just wanted to mention, there's a study that showed that children with an incarcerated parent are at greater risk of self-harm and suicide attempts, but maintaining a positive relationship with their incarcerated parent reduces the likelihood and the risks of those. So this isn't just good for the mental health and well-being of the person who's incarcerated, but also potentially their children. With that, I'd be happy to take any questions. Thank you again for hearing this bill.
Thank you. Any questions for Mr. Smith? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support? Senate Bill 1098.
Good afternoon, Chairman, members of the committee. Casey Nail here today representing Empower Missouri. Want to go on record in support. We think this is good policy. I know I, for one, feel a greater sense of motivation and feel a greater sense of accountability when I'm in regular communication with my family. And we think that people who are incarcerated should maintain that right and keep families strong and maintained. So appreciate the sponsor bringing it forward. Happy to try to answer any questions.
Any questions for Ms. Nail?
Thank you.
Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses for in opposition? Seeing none, any witnesses for informational purposes?
Beg your pardon, are we on 1115?
No, we're on 1098. Any witnesses for informational purposes? Seeing none, that'll conclude the hearing. Thank you, Senator.
Brief closing remarks?
Sure.
Oh, thank you. There are multiple House versions, and some of them have different rates. Some, I think one of them is 5 cents, so I will be working with the department to kind of find a number that works for them. So I might have an amendment to lower that rate just so the committee's tracking, but I know we have the department here today, and I'll be working with them closely to make sure everything's fair.
Great. Thank you so
Thank
much.
you.
All right, this will conclude the hearing on Senate Bill 1098. Next up, Senate Bills 744 and 1026, Senators Arthur and Brattin. Just for the benefit of the members of the committee as well as folks who are in the hearing room, these bills are substantially similar to one another, and so we're going to be hearing them at the same time. There is a slight variation. I believe there's some additional language in Senator Brattin's version of the bill. We would ask that anybody that's testifying in support or in opposition submit forms for both bills. And in the event that you are submitting in favor of one bill but not the other because of the additional provisions from Senator Brattin, if you could please note that on your witness form. But since the bills are so similar, it just seems more efficient to have a joint hearing on it. So with that, we'll open it up first to Senator Arthur and then Senator Brattin.
Mr. Chair, members of the committee, thank you very much for considering Senate Bill 744. Mr. Chair, I appreciate your willingness to hear this legislation early in session. Often there are problematic bills passed and promises to come back and fix them the next year. Senate Bill 744 represents such an attempt. Last year, the General Assembly approved a change in statute which makes 50-50 shared parenting the presumptive law as opposed to considering the child's best interest. I disagreed with that change, but I pledged to work with the then sponsor to modernize the law by updating the factors considered in custody disputes. My hope was to better reflect the modern realities of today's families and give the courts the tools they needed to evaluate those custody arrangements. Unfortunately, a promise was made to incorporate the compromise language, but that promise wasn't kept, so this 50-50 bill the shared parenting bill was ultimately passed with the problematic and non-negotiated language. So now let's talk about what this legislation changes. Factors considering the child's best interests have remained unchanged since the 1970s, and they fail to incorporate the modern family dynamics and realities of life today. Without updating these factors, we risk overlooking crucial aspects of a child's life, health, safety, and happiness. This legislation revises and expands factors for a judge to consider to encompass practical family considerations, ensuring courts have the necessary tools for holistic assessment. The revised factors include parental cooperation in child rearing and conflict resolution, I'm speaking broadly, the child's home, school, and community adjustments, including physical, emotional, and educational needs, mental and physical health of all parties, including any history of substance abuse, domestic and child abuse history, ensuring protective custody and visitation rights, distance between parental residences, and any potential relocations, the child's input, respecting their maturity and independence and safeguarding against parental influence. And our goal was to equip courts to effectively prioritize the child's best interest, minimizing disruption and trauma. I'm committed to working the legislative process this year and supporting families through their challenges in diverse circumstances. We do have expert testimony to help explain some of the custody, the factors considered in custody arrangements.
Any questions for Senator Arthur before we move on to Senator Brattin? One question I do have, and Senator, if you don't have it off the top of your head, that's fine. As I mentioned before, there are some slight variations between your version and Senator Brattin's version. Do you have a stance on those differences?
To the best of my recollection, the language we filed was the final compromise language. The differences are pretty minor, but I would argue they're probably unnecessary.
Okay, great.
Thanks.
Senator Brattin.
Well, thank you, Mr. Chairman, members of the committee. Bringing forth, it is cleanup language, Senate Bill 1026. So last session, the bill there were two versions that we passed through. One was a compromise language with Senator Arthur, with us working together on my personal bill, made it through through to the House. Unfortunately, it died. The other amendments, of which I had, said that I would do everything in my power to make sure that language was, came into what this was. Unfortunately, the House did not, move to amend that language and passed that language clean, unfortunately. So that's why we're back. There are, some minor differences. So the substantially equal change as opposed to significant but not necessarily equal, I think is one of the changes. The other is dealing with the emotional and emotionally damaging. In my opinion, I believe that factor 7 does include when you're talking the domestic violence and those sorts of things. It's already covered in that. I think if we go too expansive, the capability to utilize emotional damaging could be, just that thread that could be honestly misused in court through the court process. So I'm happy to work with Senator Arthur with the committee and try to make sure that we come up with clean language and a good language that we're able to make happen. That way we're able to follow through. That way the language also follows with case law. I know there's some ambiguity there in what case law was as opposed to what we passed last year. So that will bring all of this into line, and hopefully we'll be revisiting this every single year. So thank you, Mr. Chairman.
Questions for Senator Brattin? Seeing none. Witnesses in support. You can stay there when the witnesses testify.
Good afternoon, Senators. My name is Timothy Faber, and I appreciate the privilege to speak with you all this afternoon about these bills. I think overall both of them are good, but I would like to indicate a preference for 1026 over 744 for the reasons that Senator Brattin mentioned. While joint custody does in fact mean joint without showing a preference to one parent or the other, I think the inclusion of the emotional component might be distracting or create a lot of unintended consequences. Emotions, as we all know, are very subjective, and evaluating another person's emotions can be very subjective. And especially when we're dealing with children. Children can have emotions one moment and not have those same emotions the next moment. And so while it is a valid consideration, I don't know that they need to be a priority consideration. So for that reason, I would favor 1026, but I do believe that both bills are good. Thank you.
And so just to clarify, so you're testifying in support of both bills with a preference for another one?
Correct.
Okay. And yes, you've got your witness forms. I assume you've filled out 2 of them
Yes,
in
one for
support
each.
of both bills.
Thank you.
Great. Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon. My name is Laura Underwood, and I am a family law practitioner here in Cole County. I'm also with the Missouri Association of Family Law Advocates. We worked with both Senators Brattin and Arthur last year and several senators years before on this language that is reflected in 1026 and 744. Our preference would be for 744 because we think that the emotional needs of the children are important. That would be something that, of course, like all of the factors which need updating, would have to be proven to the court. It couldn't just simply be a parent coming in and saying the child is emotional. There would have to be facts to back that up, the evidence to back up. When they're emotional in work circumstances, theoretically, you'd have a therapist come in and talk about those things as a professional as opposed to just to a parent. So I see that the issue with the emotional needs of the child not being something that's going to be difficult for judges to determine, assuming the attorneys are doing their job and getting the therapists in there to make those recommendations. Also, there's significant but not necessarily equal versus substantially equal under 1026. Again, we support both bills. I support both bills. I filled out both witness forms. I think whether we call it significant but not necessarily equal or substantially equal, the update to the factors is what really matters and is what's going to guide the judge to determine what is substantial or what is significant. So whether you call it significant or substantial, it's really the update of the factors that are going to guide the judges and to determine exactly how that custody is divided out. Again, we worked on a lot of this language, especially when it comes to the domestic violence language, when it comes to how far apart the parties live. That's a huge factor. We had, before it was just if one's going to move, but a lot of times we've got one that's already moved, or they knew they were going to move, or the reason of the divorce is because somebody had to move. So the distance is pretty important to have that in there. I'm really excited to see that, and thank both senators for bringing this forward.
Thank you for your testimony. Questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Good afternoon, Mr. Chairman, members of the committee. My name is Angela Hirsch. I'm the Executive Director for the Rape and Abuse Crisis Service here in Jefferson City. RACS is a nonprofit agency that serves survivors of domestic violence, sexual assault, and stalking in 9 counties here in central Missouri. In 2023, we served more than 1,300 survivors with more than 18,000 services. And we know the impact that domestic violence has on families. Our services include legal, personal, case management, counseling, and emergency shelter for those who are seeking a safe place when it's not safe for them to be at home. I'm here to support Senate Bill 744 and the priority this legislation places on ensuring that the best interest of the welfare of children whose parents are seeking a custody order is considered, especially when it comes to the history of domestic violence. It's vital that courts take past domestic violence incidents into consideration when determining custody. The impacts of domestic violence among children include the following. More than 5 million children witness domestic violence each year in the United States. 40 million adult Americans grew up living with domestic violence. Children from homes with violence are much more likely to experience significant psychological problems, both short-term and long-term. Children who have experienced domestic violence often meet the diagnosis for post-traumatic stress disorder, or PTSD, and the effects on these children's brains are similar to those who experience combat or veterans. Domestic violence in childhood is directly correlated with difficulties learning. We know that children who experience domestic violence in the home have lower IQ scores, deficiencies in visual and motor skills, and problems with their attention and memory. Living with domestic violence significantly alters a child's DNA. aging them prematurely anywhere from 7 to 10 years. Children in homes with violence are physically abused or seriously neglected at a rate of 1,500% higher than that of the national average. Children who grow up with domestic violence are 6 times more likely to commit suicide and 50% more likely to abuse alcohol and drugs. If you grow up with domestic violence, you're 74% more likely to commit a violent crime against someone else. Children of domestic violence are 3 times more likely to repeat the cycle in adulthood, as growing up with domestic violence is the most significant predictor of whether or not someone will engage in or be a victim of domestic violence later in life. And we know that children who witness domestic violence suffer from anxiety, PTSD, physical challenges, aggressive behaviors, and in many instances, suffer physical abuse themselves. And finally, long-term damage to these children include depression, health problems, and repeating these abusive patterns in adulthood. Senate Bill 744 helps stop the cycle of domestic violence by ensuring that children and survivors are protected from ongoing threats and abuse. I thank Senator Author for this bill and for introducing it, and I encourage this committee to move this important legislation forward. Thank you.
Thank you for your testimony. Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon. My name is Matthew Huffman, and I serve as the Chief Public Affairs Officer for the Missouri Coalition Against Domestic and Sexual Violence. We are a statewide membership association of more than 100 domestic and sexual violence service providers. Mr. Chairman and members of the committee, thank you for your time today. As the senators have already mentioned, last year the legislature codified a presumption that every custody case starts with equal or approximately equal parenting time for each parent. The Missouri courts have long favored joint custody, but Missouri custody statutes have also long guided judges on taking into consideration domestic violence and the best way to protect survivors and their children. While we are supportive of both of these bills, we do have a preference for Senate Bill 744, and we believe that this bill can really help domestic violence survivors collect and present compelling evidence to a judge in regard to rebutting that presumption of equal parenting time. For example, we specifically like the language that is kept in this bill about equal or approximately equal in relation to rebutting the presumption of equal parenting time. We believe that keeping this language instead of changing it to substantially equal could really help make sure that the dynamics of power and control within an abusive relationship are not further exacerbated. Along with that, we also really heavily favor the way that this bill will increase the custody factors under consideration to make them much more survivor-centered. In particular, Factor 4, in which a parent is more likely to allow the child frequent, continuing, and meaningful contact with the other parent. This bill includes the willingness and ability of parents to cooperate in the rearing of the child. We believe that this change could be a positive benefit for survivors because they could present to the court and argue that they are willing but not always able to cooperate due to other safety issues and not being willing to participate because of the danger presented to them from the abusive parent. Additionally, we heavily support Factor 7 that is specific to domestic violence and child abuse. In particular, the updated language that says the court shall consider the nature and context of domestic violence and the implications of domestic violence for parenting, for the child's safety, well-being, and for developmental needs. The language requiring courts to consider how the implications of domestic violence and child abuse on parenting impact the child's safety and well-being, specifically their developmental needs, we believe can really help protect that child from further family harm. Whether it is physical, verbal, psychological harm, this is a really important step in keeping domestic violence survivors and their children from experiencing further harm. I want to say thank you to Senator Arthur for sponsoring this bill and working to keep domestic violence survivors and their families safe from experiencing further abuse. MOCA DSV supports Senate Bill 744, and we urge the committee to vote this bill out and send it on to the Senate floor. Thank you.
Great, and thank you for your testimony. And just a brief clarification, are you not offering testimony on Senator Brattin's bill one way or the other? And that's fine. I just didn't hear that in your testimony, whether you're offering testimony in support, opposition, information, or not at all on his bill.
Not at all on this
Not
bill.
at all.
On his
Great.
bill, rather.
Great, thank you so much.
Yes,
Any questions
thank you.
for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Hello, good afternoon, committee members. Good to see everyone again. My name is Jeff Miller. I am an attorney in St. Charles and St. Louis counties. I wanted to let you know, Chairman, thank you for your time today, that we strongly support 1026 with provisions from 744 built in. The problem is to explain all this to you, there was a new appellate case that came out in March of last year. I don't normally do this, but I prepared a statement. I was just going to sort of read to bring everyone up to speed on what has happened and why we're here, and then how to solve it. So, real quick, I'll try and get through this real quick. Back in 2016, the General Assembly passed House Bill 1550, which required the courts to enter facts, findings, and conclusions of law when making custody determinations. It also, within that law back in 2016, required all parenting plans to include certain language notifying the parties they may file a family access motion to request make-up time. But right after that law went into effect, in 2016, the Court of Appeals issued a case called Morgan v. Morgan, and that's at 497 Southwest 3rd, 389. In that case was October of 16, so it was right after the bill became law and became effective. That case recognized your intent in passing 1550 back in 2016, that it seeks to maximize to the highest degree the amount of time the child may spend with each parent. Because of that, Morgan said we're going to require our trial courts to enter a joint physical custody arrangement that is, quote, substantially equal. So that's where that substantially equal comes from. And I'm going to remember that phrase or word. I'll come back to it in a moment. It said what an example would be of substantially equal is Monday, Tuesday with one parent, Wednesday, Thursday with the other, and alternating weekend blocks of Friday, Saturday, and Sunday from Morgan. So that's sort of the history going back, some quick math, to 2016, 8 years or so. During the legislative session last year, the Court of Appeals issued another opinion, OHB versus LYS. That's at 665 Southwest 3rd, 329. And that came out in March 2023, just 2 months before the end of the session. It created a conflict with the then existing law under Morgan that required substantial equal parenting time. In that OHB case, real quick, the court awarded the father 4 overnights in a 14-day period and said that was sufficient for joint physical custody because, and here's the problem, because the statutory definition, which we've never looked at, touched, never had any reason to because we had Morgan anchoring the law here, but that case said it was sufficient for joint physical custody because the statutory definition of that requires an order awarding parents significant but not necessarily equal parenting time, but not necessarily equal time. That's not what we've been doing since 2016. It's not what we've been coming up here for 9 years to take a step backwards and say, well, because it's in the definition, not necessarily equal, we're okay with 4 out of 14 nights being substantially equal. I think that's problematic and why we support 1026 because it has a correction to this to add, basically codify Morgan and add substantially equal into the statute. So what needs to happen is to bring the language substantially equal from Morgan to make it clear to courts that there is a distinct starting point of 50-50, again, by codifying that language, and then just striking from the definition, but not necessarily equal. So there's 4 words. And replacing it with substantially equal, as Morgan has required ever since 2016, 8 years ago, and as we've shown in the last 9 years coming up to the Capitol. Otherwise, what will happen is it will create a conflict at the very beginning stages of any family court case, since legislation was also passed, becoming law in August, requiring equal, I think the language is equal or approximately equal. So that's in current law. That's what we did last year. It now says requiring equal or approximately equal, but 4 out of 14 is substantially equal because it says in the definition, but not necessarily equal. So it doesn't make sense. We've got a big conflict. So what's the fix? The fix is, well, we can put in language from 1026 or put in language from 744. The reason we strongly support 1026 is it just makes it clear. There's no conflict. The legislative intent is extremely clear. Since 2016, they've been pursuing this. It finally passed last year, a few months after this case came out. So that's why we need to correct. That's why we need to correct the case and codify that and bring it all together to be substantially equal. I'm more than willing to chat with anyone offline about this or answer any questions if you have any for me today. I'll fill out my 2 witness statement forms. And thank you again. You know, this has been a passion project of ours and why we keep coming up each year. So I know a lot about it. If you have any questions, be happy to answer.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon. Jeremy Roberts, St. Charles County. I just wanted to piggyback a little bit here. Mr. Miller did bring in some of the language from Senator Arthur's bill. And just to be clear, the 2 factors, one pertaining to, the one pertaining to the geographical distance we are in agreement with, and the one, there was a factor that you had put in there about pertaining to parental alienation. It becomes an actual factor where the judges are going to have to look at the interactions between the parents. Excellent. So my position would be that we're strongly in favor of 1026 with also Arthur's language, Senator Arthur's language on those 2 provisions.
Have you filled out witness forms?
I'm going to grab
delineating those 2 positions? Okay.
Yep.
Any testimony, further testimony?
Nope. Thanks.
Any questions for this witness? Seeing none, thank you for your testimony. And when you're done filling out the witness forms, just make sure we get those back before the end of the hearing. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none. Senators, any closing remarks?
Thank you.
Seeing none, this will conclude the hearing on both bills. Next up, Senator Arthur, don't move very far. We have Senator Thompson Rehder's Senate Bill 767 and Senator Arthur's 1342, as was the case with the last 2 bills, substantially similar. I believe these are actually identical. So if you're planning on testifying on either of these pieces of legislation, make sure to fill out witness forms for both of the bills. And with that, Senator Thompson Rehder will go ahead and start with you, and then Senator Arthur after that.
Thank you, Mr. Chairman, members of the committee. I am Senator Holly Thompson Rehder from Senate District 27. And this bill is a continuation of a bill that we actually passed several years ago. I myself, this bill raises the age of someone being able to get married to 18 without any exemptions. I myself got married at 15 with my mother's consent to my 21-year-old boyfriend. And at the time, I was operating in what I thought was an adult mindset. And it was only until much later, our marriage lasted 7 years, but it was only until much later that I realized at 15 years old, you really don't have the mental capacity to make those type of decisions. In the state of Missouri, you cannot lawfully sign a contract until you're 18 years old. And I believe we have some that are going to testify here today, but we've also turned in many letters of support, and those were just groups that honestly found out that through a bill search, realized that we were working on this here in Missouri. My Zonta Club, which is a women's group, came to me this past fall with this bill and asked if I would champion it for them. And of course, being someone who did get married at 15, I said absolutely. I know that it is something that we really shouldn't be doing before we're an adult. So with that, I will turn it over to Senator Arthur.
And I'll just start by saying I really appreciate Senator Thompson Rehder's leadership on this bill. And I was contacted by a constituent who asked if I would file it. I agree that it's really good policy for our state. Missouri ranks 16th when it comes to child marriage per capita. And child marriage poses serious risks to children. I think it's been a stated position of the General Assembly that we want to do everything we can to protect children, and this is a legislative action we can take. Nearly 300,000 children under the age of 18 were legally married in the U.S. between 2000 and 2018. Most of the children married were girls married to adult men. And these girls are much more likely to develop serious health conditions, experience intimate partner violence, and present with more psychiatric disorders and poor mental health. Their educational attainment and earning potential are often stunted, and for teen mothers, getting married and later divorcing can more than double the likelihood of poverty. It's also worth mentioning that the divorce rate among this group is about 70 to 80%. So if we believe in the importance of marriage, we want people to be adults as they enter into that agreement. Child brides are often coerced into marriage by abusive partners or predatory parties. Forced marriage shields child rapists and abusers from being charged with sex crimes, and forced marriage is recognized globally as a form of modern slavery and nationally as a human rights abuse. Of course, these outcomes are traumatizing for the individuals involved, but we also have to acknowledge that there's a cost to society. And by intervening with legislative action, we can protect children and limit the harm imposed. Raising the marriage age to 18 is not just legislative action, though. It's also sort of a moral imperative that protects the innocence and potential of our youth. You can picture a young girl, 16, eyes filled with dreams and aspirations, being asked to take on the responsibilities and challenges of marriage and potentially motherhood. And I would argue that's not necessarily a future we want to envision for our daughters. So with that, happy to answer any questions.
Any questions for either of the senators? Senator Coleman.
Just want to briefly thank you both for bringing this bill forward. My understanding is that we had previously passed legislation that was raising the age of marriage. Can you walk me through the history of that?
We moved it. We had started off, that was Representative Jean Evans' bill. Mm-hmm. She started off with 18, and then at the time, because like when I got married at 15, I only needed one parent's signature. And so at that time, a few years ago, we were able to get it moved from up to 16 years of age, but you couldn't marry anyone over 21. Mm-hmm. So we were able to raise the age a little and tweak it a little bit, but wasn't and I believe at that time it was because of some some communities concerned with religious freedom versus this. My answer to that is we set an age. Mm-hmm. So let's set an age that's appropriate.
No, and I appreciate that we have all kinds of limitations on age, whether it's tanning beds or having your ears pierced. So certainly whether you can enter into a legal contract like marriage, it seems appropriate that you've reached the age of majority. So thank you both for bringing this forward.
Any further questions for bill sponsors? Seeing none, first witness in support. Witnesses in support.
Thank you, Chairman, for the opportunity to address the committee today on SB 767, a bill to end child marriage. My name is Lauren Van Wagner, and I'm a survivor of child marriage. On November 3rd, 2006, my mom drove me to school. I turned in a research paper, and I was promptly checked out. We then drove to Florida from Alabama, where they had more lenient laws, so that I could be married to my 21-year-old boyfriend. I was 17 and a senior in high school. I complied with my marriage because I didn't see another option. I thought I was doing what was right by my religion, and I felt in my heart that it was what was right for me. The reality is, I wasn't mature enough to make that decision. I was only thinking of not having a curfew. That sounds great at 17, right? And preventing my ex-husband from religious excommunication. Neither of those things should have been my responsibility at that point. I wasn't thinking of the role that came with becoming a wife, or what was best for my future. The next 12 years of my life were a horror story. I dealt with abuse, lies, and infidelity in my marriage. In 2018, my husband abused me in front of my children, and he walked out the door. And for the first time in my entire life, I was alone. I didn't know what to do. I'd just gotten a job as a parent at a local school. Obviously doesn't bring in a lot of money. My car didn't work, and I lived in rural Kansas, miles from town, and I was left with 4 small children. My entire adulthood had been dedicated to my household and to being a mom. I'd only recently gone back to school, or to work. I found myself without any real job skills or continuing education. After living for 6 months on our farm without indoor running water or heat, I decided to sell the property that I loved and move to town. At that point, I relocated to the Kansas City area. With that money, I went back to school at KU and got a certificate in data analytics. And from there, I was able to find financial stability in my life. Last week, my ex-husband was sentenced to 14 months in Leavenworth prison for violating probation and making threats against women. This is the future that I could have faced if I'd stayed. My story is rare. I'm one of the lucky ones. I got out of my marriage. Under current Missouri statute, my marriage at 17 to a 21-year-old would have been legal. Between the years of 2000 and 2018, 8,007 minors were married in the state of Missouri. Just like me, these minors often become stuck in a cycle of poverty and abuse because they can't escape. Committee, as you can imagine, reciting my story is painful. However, I stand and I do it again and again and again, in hopes that one day underage girls will be safe, in hopes that I leave a better world to my own 3 daughters, one of whom is currently only 2 years younger than I was when I was wed. Missouri has the opportunity to become the first state in the Midwest to pass this legislation. The same exact legislation has been sitting in the Kansas legislature since 2021. I know because I put it there and I've testified on it, and it has not moved. You have the opportunity to take that border rivalry and just punch it back at them. This is in your court. You can beat them to the punch on this one. Thank you, Chairman and Committee, for the opportunity to speak to you today. And thank you, Senator, for your bravery in bringing forth this and sharing your story. I'm happy to stand for any questions at this time. Thank you.
Thank you for your testimony, and thank you for your courage in being here today before the committee. I know that's very difficult to talk about, so we
Thank
do
you.
appreciate it. Any questions for this witness? Seeing none, thank you for your
Thank
testimony.
you.
Further witnesses in support?
Chair, members of the committee, Jessica Petrie here on behalf of Missouri Kids First. Missouri Kids First is the network of the state's child advocacy centers that see children after they've experienced physical or sexual abuse. So we just want to reiterate the testimony from the bill sponsors that oftentimes child marriage is used as a tool to trap minors, especially minor females, in abusive relationships or in trafficking situations, or at the very least, it really impedes their ability to grow socially, economically, and have the future that we would all envision for our children. So 18 as a policy is what we have said adulthood is. This is what it takes to be an adult, this is the legal age. And we've worked in a lot of other policy areas like juvenile justice to raise the age to 18 and have a standard for the state. And we believe it's time we get our marriage laws in line and bring it to that age as well. So appreciate both the senators' work on this.
Any questions for Ms. Petrie? Seeing none, thank you for your testimony. Further witnesses in support?
Hi, it's me again, Laura Underwood, family law attorney here in Cole County. I was originally not going to testify on these bills, so I didn't realize they were on today, but I saw them when I was preparing for the other testimony. And as someone who's involved in family law, who's involved in juvenile law, I just reiterate everything that's been said today. Our sponsors have both said it more eloquently than I can as to why it is important for people to be 18, reach the age of majority for this. And for everything else, we just recently raised the age to be able to leave the juvenile justice system up to 18. So if you are 17 and create an offense in the juvenile justice system, you remain in the juvenile justice system instead of being charged as an adult. So just be just consistent across the board of making adults who are 18 years old, not 17, not 16 with permission, but 18. And so I support both of these bills. Thank you.
Thank you for your testimony. Since I know you didn't plan on testifying, I didn't know if you left a witness for. You got him right there. Perfect. You're way ahead of the game. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Hello again. Matthew Huffman with the Missouri Coalition Against Domestic and Sexual Violence. Chairman and the rest of members of the committee, thank you again for your time. Child marriage or marriage under the age of 18 has been named a human rights violation by the United Nations, and the United States Department of State views forced marriage as a human rights abuse, and in the cases of minors, a form of child abuse. Child marriage was legal in all 50 states up until 2017, and as we have heard today, many states are becoming more and more aware of how dangerous this is to be putting youth in. But with more awareness and advocacy, like both of these Senate bills, we can start to prevent this abuse from continuing to occur. Child marriage is easily a forced marriage. Minors become legal adults at the age of 18, and children under the age of 18 have very limited legal rights, which makes it easier for a child to be forced to stay in a marriage that is abusive and dangerous. Minors face overwhelmingly legal and practical barriers if they attempt to flee an abusive marriage, and children typically are not allowed to initiate a legal proceeding, such as seeking a protective order or even filing for divorce, unless they act through a guardian or other representative, and this can further isolate and endanger a child who has been forced into a marriage. Additionally, child marriage undermines our statutory rape laws. In most states and under federal law, sex with a child would otherwise be considered rape, and in some cases felony rape. But in these situations, the marriage license essentially becomes a get-out-of-jail-free card for the child rapist. Child marriage also endangers a child's overall livelihood and well-being, as we've heard today. As children enter into adulthood, this can undermine their physical, emotional, and financial safety. Child marriage is widely understood by advocacy groups to be a harmful practice that disempowers women and girls and puts them at increased risk for experiencing domestic and sexual violence. Thank you to Senators Arthur and Rehder for sponsoring these bills and working to keep young people safe. MOCA DSV supports both of these bills, and we urge the committee to also support them and bring them out to the Senate floor. Thank you.
Thank you for your testimony. Any questions for the witness? Thank you. Further witnesses in support? And we are going to ask witnesses, since we're running short on hearing time and we've got another bill to hear after this, if you could please confine your comments on this legislation to 2 minutes or less.
Not a problem.
We'd greatly appreciate it.
Hello again, Angela Hirsch, Executive Director for the Rape and Abuse Crisis Service here in Jefferson City. We support Senate Bill 767 and 1342 to raise the consent of marriage to 18, regardless of parental consent or any other exceptions that may exist. Child marriage is a cruel form of child abuse, most often affecting young girls. Girls are forced into adulthood before they are physically and mentally ready, as you've already heard. Child brides are frequently deprived of their rights to health, education, and safety. These girls are at high risk of sexual and gender-based violence. Another thing to note is that childbirth is the leading cause of death among girls between the ages of 15 and 19. In addition, child marriage is often a front for child sex trafficking, hidden behind the protection of marriage. I want to thank the two senators for bringing this legislation forward and their efforts, and we encourage this committee to allow this legislation to move forward to ensure that Missouri's youth is safe and protected. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support? Witnesses in support? Seeing none, witnesses in opposition?
Good afternoon. Timothy Faber, and I do appreciate Senator Rehder and Senator Arthur bringing this legislation forward. I think it does, to some extent, address a need, and we certainly have empathy for those who have experienced negative consequences to marrying at such an early age. I have been a minister for 40 years, and personally, I've never conducted a wedding ceremony for somebody under the age of 18. However, I can see a few rare circumstances where that might be appropriate. As I said, this certainly addresses a need. We have empathy for those. We don't like the fact that it totally closes the door. That door for children, minors under the age of 18 to get married certainly needs to be tightened up, narrowed in some way, we could talk about that, but to just absolutely close the door, can't support that. There are, my brain just blacked out on me.
Let me ask you a question really quick.
Okay.
In terms of national standards, do you have any statistics or data as to what the national average is of the minimum marriage age among the other states?
I do not. I do know that our neighbors to the south don't let you marry your cousin, contrary to their stereotype, but our neighbors to the east will. But as far as age, I'm not that familiar. No.
Okay, so in terms of right now, Missouri is 16 and 17 with parental consent. 18, obviously, you've got full capacity, and you're not aware of the other 49 states what the minimum age of marriage is without parental consent.
No.
Okay.
I've lived almost my entire life in Missouri. Spent a little bit of time in Indiana, but I didn't check the youngest allowed in Indiana because, I typically don't, I've never been asked to marry anybody under 18, so I've never really made it an issue. I do know what I was going to say a while ago. While there are many examples of those who've gotten married before they were 18, ending up in abuse and divorce, there are many examples of people who got married after 18 whose marriages have failed as well. So, like I said, it's certainly not something anyone would advocate for, divorce or abuse, but I believe there's other ways to address this issue.
Any further questions for the witness? Senator Trent.
Yes. What would prevent someone who wished to get married in a way that this bill prohibits from simply waiting until they turn 18 and then getting married?
Well, one instance I can think of, perhaps there's a bride or a groom that they're already engaged, and a parent or a grandparent or another significant person in their life is terminal, and a bride in particular might really want her dad to walk her down the aisle.
Couldn't they have ceremony of that variety without the binding legal?
I suppose that's possible, but they're not going to want to live together if they're not yet married legally. And then we can get into whole issues of
Well, I know, but if
legal
someone
marriage
wants to
versus religious
experience
marriage and
a
such.
ceremony, that's a little bit different from binding legal contract.
Right. Well, again, we get into the differences between a legal marriage and a religious marriage. Obviously, religious marriages predate legal marriages by millennia.
So I guess I'm just not seeing what situation that this would prevent that would, like you've tried to identify like some rare circumstances where, the bill might be too restrictive, but I'm not sure that any have been identified yet.
Okay. I just, to close the door totally just seems too much. I think we ought to certainly tighten it up. Maybe it needs to be a parent and a court, or a guardian ad litem if there is one, or whatever the case might be. Maybe it needs to be 2 parties or 3 parties sign off on it instead of 1. But to just totally close the door is where I would say that's a little too far.
Okay, appreciate your testimony.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition? Further witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, senators, any closing remarks?
Thank you, members of the committee. And Mr. Chairman, I would like to close with just saying at 15, I got pregnant 4 months later. And for the time that my husband and I weren't together, I couldn't find a job because I was too young to work. And so in order to support myself alone and supporting myself, I cleaned houses for a living and did nanny work. But that was all that I could get because I was a child. And I think that needs to be heavily considered. Years ago, when our great-grandparents got married very early, that was before women had the opportunity that they have now of education and many other things. And so this is something that I think protects our girls and gives them a start like anyone else in making them make these choices as adults instead of children. Thank you.
Thank you, senators. That will conclude the hearing on those bills. Next up, Senate Bill 1115. Senator Schroer, whenever you are ready.
Thank you, Mr. Chair. Members of the committee, for the record, Nick Schroer, Senate District 2, on Senate Bill 1015. I will state that after I present the testimony, I will have to jump over and present another bill next door. So if there are any questions that we miss, I will be happy to answer them on or off the record. The bill, as we sit here today, 1115, has 7 prongs to it, most of which have already been through this committee. Have actually gone to the governor's desk. So I can concentrate on those. But I do want to say that we are going to make some adjustments, and the chairman and I are working on a substitute which has not been finalized yet. I'm going to go over some of the prongs that the committee has either seen. We've either passed it, the governor has signed it in the previous Senate bill that was vetoed last year. Get you that number here in just a second. On 189. Or other prongs that the committee will hear or has heard this year. So within the sub, we're going to have the telecommunicator first responders, the residency requirements for St. Louis and the public safety employees, compensation for peace officers, peer support counseling programs, jurisdiction for juvenile courts, certification of juveniles for trial as adults, eligibility for parole for juveniles, workers' compensation for first responders, the voluntary critical illness benefits pool, arrests for traffic violations, Judicial Privacy Act, exclusion of personal information on minors in court documents, motion to vacate or set aside judgment, conviction review unit, mental health services for detainees, persistent offenders in 558-016, minimum prison terms for armed criminal actions, credit for time served, unlawful posting of certain information in 565-240, Cybercrimes Task Force, offense of endangering the welfare of a child, Blair's Law, offense of unlawful possession of a firearm, Max's Law, offense of delivery of controlled substance, drug trafficking, fentanyl testing, critical incident stress management program, civilian review boards, rights of victims of crimes, public defender fund, expungement of criminal records, and compensation for wrongful convictions. As stated before, we should have the substitute language Mr. Chairman, if you don't already have it, we should have it here within the next day or so. That'll get distributed, and we can talk more about that. But I'd be open to any questions on the underlying bill or the prongs that we are going to include in the substitute.
Any questions for Senator Schroer? Thank you for your testimony.
Thank you.
Witnesses in support of Senate Bill 1115.
Thank you, Mr. Chairman. Terry Briggs. I'm the mayor of the city of Bridgeton up in St. Louis County, adjacent to the airport up there. Specifically, my comments are geared towards Section 211, which is assessment of juveniles. I'll give you one quick example because I did provide some written testimony. We had a case in 2022 when a 17-year-old came up to our municipal pool in the afternoon with another individual and started making taunts, and eventually got to the point that he was pointing his finger like he had a gun, pointing. The Bridgeton officers were called to the scene. This was in the late evening. The individual ran from the officers and threw away a bag on his way out. In the bag, which was retained, we found a pistol along with several bags of ammunition. The individual was taken in by the officers and taken down to our juvenile courts down in the city of Clayton in St. Louis County. Juvenile officers, he was being charged with terrorism and trespass. The juvenile officer at the time failed to detain. 3 months later, the same individual was involved in a shooting in a Bridgeton neighborhood, shot 2 other juveniles. The individual could have been detained, could have been put into programming a lot sooner had he been detained the first time around in July. Instead, in October, he injured 2 juveniles. Finally, the juvenile courts used the assessment tool as we see it should have been proper, and that is they went ahead and put him into detainment, and he's now receiving treatment. The intent of this is not to say that every juvenile that allegedly commits a crime should be incarcerated. However, there are times, and especially with our police officers, when they take down individuals, juveniles who allegedly commit a crime, and then they're released. In some of the counties surrounding us, most notably Senator Schroer's County of St. Charles, Senator Coleman's County in Jefferson, they take a more stricter stand on it. The assessments are a little bit different. What we're saying in this provision is that assessments of all the alleged crimes committed should be used when a juvenile officer determines whether or not detainment should be merited. I'll be happy to answer any questions for you, Mr. Chairman. I know you're on a time schedule.
Thank you, Mr. Mayor. Any questions for this witness? Very briefly. Yep. Senator Roberts.
Mr. Mayor, thank you so much for coming out here today.
Thank you, Senator Roberts.
Of course. And your comments kind of touched on some legislation that I've been working on. Minors in possession of firearms are one of 2 states that don't have that provision. When I think of the story you used, unfortunately, our juvenile officers aren't able to detain minors for a period over 24 hours if they're caught with a gun. Would you consider supporting legislation to address
We could
that?
consider supporting legislation like that because in this particular case, the minor was caught with a gun. And I've got several examples, but I've limited my time because I know you're stretched. Thank
Mr.
you.
Mayor. Appreciate it.
Any other questions?
Any other questions for the witness? Seeing none, thank you for your testimony. Further witnesses
Thank you.
in support of 1115.
Mr. Chairman, committee members, my name is Pat Kelly. I'm the Executive Director of Municipal League of Metro St. Louis. We're in support of Senate Bill 1115, specifically related to the juvenile detention scoring system. Just a little bit of background. In 2012, the Supreme Court set down a Rule 28, that was designed to ensure that when a juvenile is brought to a detention center, that they're treated the same. They use a scoring system for determining whether that juvenile should be held over or not. What's happening today with our juvenile detention centers is that they're not being treated the same. Some detention centers are using a process like St. Louis County where they only use the most egregious pending offense and using and evaluating and scoring them to determine whether they should be detained or not. We think that they should use all of those potential charges when they're using the scoring system. This isn't to say that we want every juvenile that's brought into the detention center to be thrown in jail and the key thrown away. What's happening is that because they're being released, they're not getting the services they need that may help them not be brought back to the detention center in the future. So we very much support this bill. We've been working in conjunction with the St. Louis Area Police Chiefs Association for more than 2 years on this, and we feel that it will help with some of the juvenile crimes that we're experiencing in St. Louis region and throughout the entire state for that matter. I'd be happy to answer any questions.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support of Senate Bill 1115.
Good afternoon, members of the committee. Philip Arnzen with the Missouri Chamber of Commerce and Industry, and we'd like to go on the record in support. Public safety is an economic issue. Back in October, we did our annual CEO survey, and 90% of business leaders said that public safety was either their top concern or a growing concern of theirs when it comes to the health of their business and continuing to do business in Missouri. That plays into their plans to expand and grow. It plays into entrepreneurs' plans on where to locate, and also existing businesses' plans to, come and relocate into Missouri. So we believe this bill has a good all-the-above approach of dealing with public safety, and hopefully, this bill gets passed and we can help address some of the crime issues we've had around the state.
Any questions for Mr. Arnzen? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1115.
Good afternoon, Mr. Chairman, members of the committee. James Harris, I'm registered lobbyist here to testify in support on both the Opportunity Solution Project and Cicero Action. And with that, I'm happy to answer any questions.
Great. Any questions for Mr. Harris? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1115. Seeing none, any witnesses in opposition to Senate Bill 1115?
Good afternoon. My name is Dan Beets. I'm an attorney. I practice out of Columbia. I've practiced for 38 years in every circuit in the state of Missouri. I had the honor of serving a few years back on the Missouri Bar Committee that rewrote the entire Missouri Criminal Code. And so I have some relevant background. During that rewrite of the code, which became effective in 2017, one of the things we did was to remove a provision that was known as the prior and persistent drug offender law, which provided that if you had a couple of prior drug offenses, you could be sent to prison for life without possibility of probation or parole for your third. A man named Jeff Mazansky over in Sedalia was convicted under that law. He had possessed a couple of ounces, sold an ounce of marijuana, then got caught briefly, very briefly, in possession of a couple of pounds. He was sentenced to life without possibility of probation or parole. Under a law similar to what I think I heard is maybe going to be proposed here, perhaps in the substitute law. But in general, by the way, I represent the Missouri Association of Criminal Defense Lawyers. I'm a volunteer lobbyist, not a registered lobbyist. The general trend of legislation in recent years, I think it's fair to say nationally, has been to reduce the use of mandatory sentencing laws. Mandatory sentencing laws imply that we can't trust our judges, that the judiciary is somehow unable or unwilling to enforce the law. I can guarantee you that is not the case. As I say, I've practiced criminal law in every circuit in this state over 38 years. I've never found a judge that wasn't willing to send a person to prison when the case merited that outcome. But every case should be judged on its merits, on the facts of each individual case, not subject to a broad umbrella that mandates that prison be imposed simply because of the nature of the offense the prosecutor has chosen to charge. But
so I'm going to let you continue. That was the 2-minute warning, but I do have a question for you. So I guess the provision that you're referencing is Section 558.016 under Senator Schroer's bill. It adds to the definition of persistent offender any individual who's found guilty of a dangerous felony.
Of a single prior dangerous felony.
Right, but DWIs are not under the definition of dangerous felony, are they?
Not that I'm aware of.
Okay, so I guess my question is the example that you pointed out,
Mhm.
where the claim was made that he's reintroducing in this section the concept of life without parole for a DWI offense?
No, not for a DWI. I think you misunderstood me. I did not. I did not mean to say or imply for
Okay,
DWI.
I misunderstood that then, because I was reading this, I'm like, I don't think that it does
No,
that,
no,
so-
I agree. It doesn't
Okay.
do that. And I'll tell you, we do support, of course, the expansion of eligibility for expungement, and this bill would expand eligibility for DWIs to be expunged. So it is relevant in that sense. But I'll tell you, perhaps our greatest concern is the impact that this would have on the ancient and honorable tradition of dueling, which could be charged both as a dangerous felony and an armed criminal action. And those who engage in dueling under this law could face extremely harsh penalties. So I hope that the substitute will take that into account. And I thank you.
Thank you for your testimony.
Any other
for this
questions?
witness? Dueling related or otherwise?
Yes. Thank
Seeing
you.
none, thank you for your testimony. Further witnesses in opposition?
Thank you, Mr. Chair, members of the committee. Sharon Galway-Jones here today on behalf of the Missouri State Conference of the NAACP. We have worked on bills like this with both the sponsor and the chair in the past. We're happy to do it again. The one part that is especially concerning to us and is why I felt compelled to actually testify instead of just help with the language is the enhanced penalties and other prohibitions on protesting, unlawful assembly, rioting, that sort of thing. We think that there's a huge freedom of speech issue there, and the penalty enhancements go from 15 days in your local jail, which is currently the most you can be penalized, sentenced to, up to 7 years in prison. And I believe for a second offense, it's Class C felony, and all of the attorneys in the room are going to judge me for not being able to remember, but I believe that one is 7 years. So it's a pretty significant enhancement for something that is pretty fundamental to the way our government operates, and we'd appreciate that part being taken out.
Any questions for Ms. Jones? Seeing none, thank you
Thank
for
you.
your testimony. Further witnesses in opposition to Senate Bill 1115?
Thank you, Mr. Chair, members of the committee. My name is Ben Miller. I am the prosecuting attorney for Callaway County. I'm here testifying in opposition to the underlying bill, specifically in regards to the special prosecuting attorney piece. Generally, we've been in conversations with Senator Schroer and Representative Hicks on the House side. Ultimately, what it comes down to our opposition here is that we want to make sure that we've got good data to drive the decision made to when a special prosecutor can be appointed, should be appointed, when any kind of provision kicks in. I will tell all of you that our association has been working hard over the last couple years to get all of our prosecuting attorneys' offices on the same case management system. The importance of that is it gives us the ability to get metrics in regards to age of case, referrals, declines, the types of cases that get declined. That way we can have a more full conversation about what this system would look like if it were to come into play. And so ultimately what it comes down to is, I'm a big fella. I went to my doctor this week and he said I needed to lose some weight. In order to do that, he took my blood, we looked at my blood sugar, we looked at my cholesterol to come up with a plan that works for me. What we're asking for is the time to do the same thing, to look at our system, to look at the data, to look at how different offices and different regions are prosecuting cases, and then be able to sit down at the table with the senator and the representative in the House and kind of work through what that looks like.
Thank you for your testimony. Any questions for the witness? Seeing none, thank you for
Thank
your
you.
testimony. Further witnesses in opposition to Senate Bill 1115?
Good afternoon, Casey Nail, representing Empower Missouri. Just want to go on record in opposition, particularly two components. The special prosecutor, Empower Missouri's position is best. Yeah, hit my 2 minutes. So we just think that that's something that should be left as a local issue, and then also have concerns around that organized protesting and rioting is a dangerous felony for those reasons that Ms. Jones already articulated. So with that, happy to try to take any questions.
Perfect. Any questions for Ms. Nail? Seeing none, thank you for your testimony.
Thank you for letting me go over time as well.
Further witnesses in opposition to Senate Bill 1115? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 1115. No further business coming before the committee. I would make a motion that we adjourn. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are adjourned.